My name is Paige Rivard. I'm the CEO of PWSA USA, and we are so excited today to bring you our School Success Summit. I know personally my 12-year-old son who's living with PWS, who's in 6th grade. Our journey, our school journey has been a learning curve, and we continue to learn as we go. And we're happy to share all the information we're sharing today and resources. And we're hoping that it will answer some of your questions, spark some new questions, and that you will have a little bit of an easier school journey just for participating today. And this is our 3rd session of the day. So the first 2 sessions were wonderful. The first session we heard from Mackenzie, and she talked about IEPs and BIPs. And the second session, Amy McTighe spoke about IEPs as well, but included some sections of the IEPs to particularly pay attention to, about transition planning, extracurricular activities in the school setting. But again, we have had 2 great sessions. We have 2 more great sessions. And all of our presentations will be recorded, and they will be posted on our website and our YouTube channel. And I'm actually going to turn it over to Stacy Ward now. Stacy's our Director of Family Support, and Stacy will introduce our next speaker. Stacy.
All right, thank you, Paige. And thank you, Elizabeth, for joining us again. For those of you who may not know, Elizabeth presented a little over a year ago on compensatory education issues for us. So go to our YouTube channel, our website, take a look at that presentation if you haven't seen it. So today, Elizabeth Eynon-Kokrda is joining us to talk about due process. Elizabeth is a founding member of the Managing Attorney for Education Rights Council, a nonprofit advocating for educational equity for pre-K to 12 school students in Nebraska. Elizabeth is also a private practitioner representing teachers, families, and districts in education matters. In her over 20 years of experience, Elizabeth has served as the chair of the National Council of School Attorneys, as well as the president of the Nebraska Council of School Attorneys. Her extensive legislative experience has developed her passion for working to improve education laws at the state and the federal level. So Elizabeth, thank you so much for taking the time to work with us. I'm particularly excited that you're able to look at things from both the parent perspective and the education body perspective. So thank you so much.
Thank you so much. Yes, and most of my advocacy is obviously on behalf of children and families, but it has been very helpful to have worked with school districts to understand what they see, and as you all know, the magic language that they speak, which I work hard on, demystifying every day. So today I was asked to speak about a really fun topic called due process. So I'm going to be focusing on what that is and both the strengths and weaknesses of basically how to get remedies when things go wrong. So let me give you a quick introduction to Education Rights Council. As you heard, our vision is that all students stay in school and thrive. And what we do is try to remove legal barriers that stand between kids. What's unique about our particular organization is we are attorneys. So unlike other advocacy organizations where they can't actually take that next step into due process, we can and we do. Our goal today is to support, inform, and empower your understanding of parental rights and due process. I am going to try and conclude my remarks within 45 minutes so that if people have questions, we will have time to answer them. So please excuse me if I'm rocking right along. I promise at the end, I will make sure to go back and clarify if you do have a question. The first really thing we always ask ourselves is, what do students with disabilities have guaranteed to them? You all know the answer to that. The answer to that is a free, appropriate public education, or FAPE. I got to get my clicker working. There we go. So part of a free, appropriate public education arises out of these notions of equity and the notion of our federal constitutional due process. But these are notions that underline an actual statutory due process that is part of IDEA itself. For those of you that are familiar with the various protections for students with disabilities. You have ADA, you have 504, and you have IDEA. All of them provide protections at the same time. Only IDEA has actual statutory due process requirements because it's an actual education law that's adopted by states, as opposed to civil rights laws, which are what ADA and 504 are. The point being that before you deprive somebody of life, liberty, or property, you have to give them due process. And of course, education is part of those rights under state law, not federal law. So quick reminder of where that all comes from. As I said, IDEA is an education law, Section 504 and ADA are civil rights. The funding is what drives what your obligations are. You know that you get FAPE under both IDEA and 504. You understand, I believe, the various disabilities that fall under these categories and your rights, but this is where everything that leads to this notion of due process comes from. Your right to FAPE under Section 504 can be brought immediately under due process, and I'm bringing this up because you do not, if it's a unique 504, which is actually just pure discrimination on the basis of disability. So setting aside IDEA, if you have a discrimination case, you do not have to exhaust all of the remedies that I'm going to talk about that are under IDEA. Under IDEA, there's an entire set of due processes that we're going to talk about. So what are we going to be arguing about if we want due process? We're arguing that the right to FAPE under IDEA was not met. In other words, you believe that you have an IEP that was not reasonably calculated to enable your child to make progress appropriate in light of the child's circumstances. And you all know that those disagreements can arise in myriad formats. Every child is unique. Every time something happens in the district, it's unique. So there isn't like a pattern of one size fits all to say, oh, here, just check this off and voila. We either have a due process case or we don't. It's all with regard to the individual rights of your child. But what we're talking about today is how to effectuate those rights. So all of these areas are where rights arise. So in other words, you may need a remedy because child find wasn't followed. Your child was not appropriately identified. You may have a claim based on the verification. Your child was misverified and therefore you didn't get the services. You may have a claim under the IEP. You may have a claim because of the least restrictive environment. Your child is not being educated with their peers. You may have a claim that's purely limited to a denial of an individual education evaluation that you've requested. You may have a claim that arises under behavior intervention plans that may or may not have been implemented appropriately, or you may have a claim that transition services weren't appropriately provided. I guess my point here is this is a really big, broad area. So I have to speak in big, broad terms rather than individual, what about this particular case, in order to present this in a manageable way. I think I spoke quickly about FAPE under IDEA and the difference between the standards of IDEA and 504. So the reason I go over these is this is where if you had a claim, it would arise. So you basically have to make sure that you got the services at no cost, you got any necessarily supplementary aids, you got services that meet your child's unique needs, that prepared your child for the future, that LRE in the least restrictive environment with non-disabled peers as appropriate, given your appropriate assessments. The other time that sometimes due process arises is when you have not been given an appropriate evaluation, or you have been not given an appropriate reevaluation, or those evaluations weren't timely. I have basically filed in lots of those types of cases where it's a more specific, very targeted, there's a rule and you violated a rule and it deprived me of FAPE. We're going to talk about when rules arise to a deprivation of a free appropriate public education, and when they are simply rule breaking, but you're still not going to get a decision that's in your favor. So the challenge with this whole situation is reasonable people can disagree about what an appropriate education is in a particular situation. One of the things that we need to get out of the way right up front is, does IDEA actually require your child to achieve a particular level? And the answer there is no. So you can't bring a claim just because your child didn't, I don't know, learn to the 5th grade level, because there's no guarantee that they'll actually learn the material. There is a guarantee that it has to be offered, and offered in a way that's accessible to your child, such that your child can make progress. So the one case that everybody talks about, and that I talk about particularly here because I'm in what's called the 8th Circuit, and the 8th Circuit was one of those before the Andrew F. case in Colorado, that basically said, if a school district gives you anything, that's kind of good enough. And Andrew F. changed that to the meaningful and challenging objectives standard that we have today. But one of the challenges that's hard for families is, and I use this with my clients, and it's a very well-worn analogy, but it does come from the 6th Court, which is, what you get is not a Caddy. You get a Chevrolet. If it's getting you from point A to point B and you're making progress, you don't get the ideal. However, if you've got a Chevy that's missing 2 wheels, now we have a problem. So I want to make clear that because due process is a complicated thing, you want to bring a due process case when you literally don't even have the Chevy. It's not a working vehicle. What is the level of expected progress? When a child's not fully integrated in the regular classroom and is not able to achieve on grade level, his IEP need not aim for grade level advancement. In other words, depending on where your child is, whether they're in the LRE, which could be, you may have a child that's fully integrated into your gen ed classroom with individual supports in the classroom, or you may be pulling a child out. The educational program doesn't guarantee that he's going to pass from 5th grade to 6th grade at the same level as his peers, but his education program has to be appropriately ambitious in light of circumstances, just as advancement from grade to grade is appropriately ambitious for most children in the regular classroom. The goals differ, but every child should have the chance to meet challenging objectives. I have been in IEPs, more than one, where we have the progress notes. The progress notes are coming back and the child isn't making progress yet. I mean, they're kind of holding static, and they say, oh, well, that's progress because they're not going backwards. People, that's not progress. We actually have to see progress, but it may not be as much progress as a child who does not have a verification or does not have a disability standing in between the child and the child's ability to access education. Here's examples of what would be the denials that you would probably want to bring due process. They fail to provide special ed in or related services included. So in other words, it's in your IP and they don't get it. You may be able to bring a state complaint there instead of a due process complaint. I'll distinguish between those later, but please hold that thought, state versus due process. If the only problem is you have an IEP and it says my kid's supposed to get 30 minutes of speech a day and my kid is not getting that, you may be able to file a pure state complaint and get a remedy. Another one is the school fails to provide accommodations that are included in their IEP. Same thing. That could be a state complaint or a due process complaint. The school fails to properly assess your child in all areas where they're suspected. That's a violation of faith. The school inappropriately assesses your child. That's where you ask for an IEE unless the inappropriateness was they assessed your child without your permission. That would be a violation of your rights as a parent. Parents do have independent rights to access due process because they have independent rights under IDEA, separate and apart from those of your children. For example, you all know, I believe, that you have a right to what's called meaningful participation. So nobody gets to come in and say, okay, Elizabeth, so glad you're here. Let me tell you what we're going to do. We're going to give you these goals, and you're going to get 30 minutes each. Any questions? That's predetermination. You were not able to actually participate. It was already decided for you. That will be a denial of faith that you have as a parent. We have the child is inappropriately placed. That could be a multitude of things, right? That could be in the wrong, what I call it, level, because they're not giving your child what they said they would. That could be your child is not being given access in the least restrictive, or your child is being forced into a general education classroom when your child really needs more specific one-on-one, perhaps in a in a more restrictive environment, so that they can stay focused and access. And finally, the school might have had an IEP meeting without notifying you. That would be another giant immediate no. I know I was denied my right to faith. Like I said, there are two kinds of denial. The first kind is procedural. So did they forget to send you prior written notice? Did they, let's say, not do something within the time frames? Okay. Is there an applicable procedural requirement is the first question. And if so, does the proof show they violated? And if so, did the violation result in, quote, requisite loss? So in other words, if they mess up because they're sloppy and it's annoying, but you actually didn't lose access to the free appropriate public education, you're not going to win a due process case. You might be able to take a state complaint and say, it is a pattern and practice of this district to be sloppy, and have the state investigate them. But it's not going to rise to a denial of faith unless it was so significant it impeded your ability to participate. So in other words, predetermination, or they had the IEP without you, without giving you notice. All right, that's a procedural violation, but it's a very serious violation. It actually deprived you of a significant right to meaningful participation. So there's sort of a sliding scale on procedural denial. Substantive denial is something like the IEP actually isn't calculated to provide faith. Let me give you an example of that, which I just filed the due process on less than a week ago. I had a child who had been in one district where the child was succeeding, came into the new district. The new district had, when the child left, they'd been there, they left. When they left, they said, okay, you're no longer getting special education from us because you've moved to this new district that's still in the same city. Child came back. They never asked to evaluate again. They never asked to put in accommodations. Child started not coming. Child moves again. Child comes back again. Same thing. The school district then proposed to say, well, we know that the last evaluation was 10 years ago. And we know the last IEP you had with us is 5 years ago. But, we're just going to go ahead with that. The answer is, really? Let me see how that's going to provide me with present levels that are meaningful so that I can create an IEP. So I'm giving you this really happened less than a week ago, but it's an outrageous example. I'm always shocked at how there are so many outrageous examples, but they're there. So anyway, substantive is it reasonably calculated to enable somebody to make progress? Is it in the integrated setting? If it's in a self-contained setting, is the IEP appropriately ambitious, including those challenging objectives, even if the same advancement as gen ed peers is not anticipated? That's when you're going to have a substantive denial of faith. I would also look and say that failure to implement an IEP is different among different courts. So for those of you who aren't lawyers, which is probably most of you, although I don't know, when you are in different circuits, there may be different standards to apply, different tests. So depending on where you are, there's going to be a body of case law. In other words, a body of cases that have had decisions made that set tests as to whether or not the school district actually failed to implement your existing IEP. There's 3 or 4 different tests. The first one is the per se. Is the failure more than de minimis? In other words, was there a failure, and was it anything more than so tiny we don't care? Is the failure significant or substantial? There's a difference between more than de minimis and significant or substantial. So some courts are more lenient, if you will, and say, hey, anything more than so minor, who cares, is going to be, whereas others are saying, no, you have to really show, you have to meet a higher bar. And then a third test is the materiality. Is the failure not only so significant or substantial, but also depriving a benefit? So in other words, there are multiple things you have to show in due process. Please understand that when I'm talking about due process, I'm sort of talking about a mini court hearing. Each state has a right to have due process in a slightly different manner. States either have like 1 level of hearing officers or 2 levels of hearing officers before you can actually take it to an actual district court. So here I'm talking about, after we've gone through those levels, what do courts say? So in other words, due process starts along a continuum, and it can take multiple years literally to effectuate your rights fully if you go through the full process. The last thing is courts talk about the capacity to implement, and is the school capable in terms of staffing and facilities to implement the proposed IEP? What you all do know, though, is if there's a proposed IEP and everybody said these are what the needs are, and our district can't meet it, it is incumbent upon the district to find a place that meets it. This is where sometimes private placement comes into play. We'll talk a little bit more about that. So FAPE does not require a school to provide that Cadillac, maximize the student's potential, provide very specific classes, offer a very specific educational, well, you have to have a specific educational program, but it's not one that's predefined by some other entity. It's defined by the IEP, which is the whole team. And unfortunately, parents can lose in that process. It does not guarantee a student with disabilities a particular spot on a sport or extracurricular. It does not require a school to give preferential treatment in a sport or club. So there's a lot of things that are not a denial of FAPE, so you would not be bringing due process. This is the slide I always try to give to parents before we actually say, okay, we're going to have to go ahead and take legal action. You may have already tried all these, but it never fails to talk with the teacher, try to negotiate a compromise, document your concerns in writing, contact the superintendent, request yet another IEP meeting. I have gone to IEP after IEP after IEP trying to reach a resolution to avoid going through due process when it is a more complex type of situation where you're getting some, they seem to be trying, but then oops, they slip, and oops, they slip. So it's more of a gray area. It's not one of those really obvious, oh my gosh, you haven't evaluated my kid in 10 years type of situation. You could request a transfer inter-district to a better building that might meet your needs. Sometimes, let's face it, the leadership in a building makes a very big difference as to the success of your child in that building. You can file, some school districts permit you to file a complaint directly with them. And then you can also consider filing a complaint with the Office for Civil Rights. This would be when you believe what they're doing is not an IDEA per se. It's just a pure, you know what, we don't do that for kids with that kind of disability. That can be a flat out discrimination on the, you're not giving me what my child needs based on their disability. For example, I had a child who was deaf because of COVID, and it's a weird thing, it was a neurologic thing. And the school said, well, then you have to go to a school where they teach ASL. And the daughter was like, I don't speak ASL, I'm 18, why would I change schools? Because that's where we have anybody who's deaf goes, no matter what. That's discrimination on the basis of disability. It also was a denial of FAPE, but you can, I'm trying to explain how you can see that there's a difference between those two things. Okay, now we're going to get to the actual dispute resolution. When all those informal efforts have proved unsuccessful, there are 3 formal dispute mechanisms that are in IDEA. And you may see those explained differently by your particular Department of Education, but they have to offer all 3 of these. In Nebraska, where I am, they also offer a 4th, which is called a facilitated meeting. So what they say is if everybody's grumpy and we're both at loggerheads, school and family, maybe if we bring a third party that's a third party neutral, it's usually a teacher that's been trained or a special administrator that's been trained on facilitating meetings that comes, they're not even a mediator, they just will facilitate a meeting. We have that in Nebraska, but it's not required under IDEA. Under IDEA, they are required to have mediators. A trained mediator will try to talk to you about the conflict. So let me tell you a little bit about mediation. Mediation is, if I'm a mediator, I happen to be a trained mediator. What my obligation as a trained mediator is to get what is the underlying want of each party, rather than the demand, and see if we can find a compromise. So let me give you an example. I really want my child to be able to be involved generally in sports. So I decide my child has to go to basketball. So I say, give me basketball or else. But my real underlying desire is that participation. So a mediator will try and find, is there something underlying where we can find a compromise? The challenge with mediation is if you go in without counsel, you may not be aware that you are giving away rights that you have under IDEA if you're not like really fluent about what the school district has to provide. And the mediator will not say, parent, I don't know if you want to do that because you have a right to that. Do you really want to give up something that you have a right to? So mediation can work, but I'm hesitant because school districts usually bring their counsel to the mediation. So even though it's mediation, it is lopsided because there's power in the school that a non-represented parent may not have. Nonetheless, mediation is one option. The other thing I would say is while there are trained mediators in all states to do this, they don't get paid a lot. They're not like the trained mediator that is a partner in a law firm. I have mediated cases with a mediator that is a true law firm, lawyer trained mediator. Mediators from the State Department of Eds do not have to be lawyers. So there's a difference in how you define mediation. Either way, mediation by a state person paid for by the state is your first step. You can skip that. You never have to do mediation. You can file a state complaint. I alluded to what is a state complaint. Generally, a state complaint arises when you think that either a district has a pattern of practice of doing something wrong. Let me give you an example of that. You all know that you have a right to an initial evaluation for your child within 45 school days or 60 days total. Let's say, which has happened, school districts have decided that doesn't count over the summer because we don't have staff. So we have done our child plan and we think your child should be evaluated. So we're going to have you consent to the evaluation at the end of May, but we won't get it done until August when everybody's back. That's a pattern or practice of violating a requirement of IDEA where you would complain to the state and say, hey, the district is doing this to everybody. A different state complaint is, this is only about me. It's my kid, but they aren't following my IEP. And here's how, boom, boom, boom. In each of those cases, what you do is it's usually just a form that you can file online. You file that complaint and then the state sort of takes over. So it's not you against the district. It's essentially state against the district. The state looks at your complaint, decides to figure it out, goes to the district, figures out what's going on. And then if the state thinks the district is messed up, the state will have the district make it right. However, under a state complaint, states don't have the power to order all the remedies that would be available under due process. What you can anticipate as a remedy under a state complaint is that you would get maybe compensatory education. You might get training of the staff. You may get an order to do an IEP that is meeting your child's needs, but generally that's it. Then finally, there's the due process complaint, which I think it's hard when people say talk about due process. We use due process in such a multiple ways. That's why I sort of started talking out at the beginning. What is the whole idea of due process, which really is basically two things. It's notice and an opportunity to be heard. And then all the entities have to describe, what does that look like? How are we going to give you notice? How are we going to give you an opportunity to be heard? What are the levels? And then IDEA defines levels specifically for IDEA violations. That's the due process that I'm going to talk about now. That's an actual legal process used by parents and districts to make a decision on issues within a hearing framework. The hearing officer's decision is final and binding unless it's appealed. And this is where it looks like what I want to call a mini trial. And the reason I say mini trial is because you are never required to have a lawyer help you with this. Things like rules of evidence don't apply. You're not actually before a judge unless it's an administrative law judge, which is different than the district court. And so it's a mini trial. It can last days, but it's not quite as rigorous as a full trial because some of the things like rules of evidence don't apply. I don't like to say this, but they're not really easy. Special education litigation can be complex, so you shouldn't undertake it lightly. You should pursue it if there's no other reasonable alternative, or if there's a really urgent issue. Now, let me give you a really urgent issue. Remember that child that I was telling you about that was deaf and they wanted her to move schools? That was a pure ADA or a Section 504. It was discrimination on the basis of disability. Nonetheless, I filed an IDEA claim. And the reason I did that is because one of the remedies that you get if somebody is changing your educational program means the services and or the placement. It's not just a building. Placement is the whole program. Somebody's changing that and you don't want it changed. If you file IDEA, the very next thing you can do is file what's called a motion to stay put. And stay put means while we fight this out, I get what I had. You wanted to change it. I don't want it changed. It's the one place in the whole process where the schools, frankly, don't have the upper hand. Schools have the upper hand, as you all know, in the team meetings because you're always outnumbered. But here, if you don't want that, it might be a time to file that complaint, and you may end up proceeding all the way through the trial, or you may end up getting to settlement. But in the meantime, you've got your child where you want them to be. Settlement. The other reason you shouldn't take due process too lightly, and or you should, if you file, seek settlement, is because you can propose almost any type of settlement. And you're likely going to get more in settlement than a judicial ruling. In other words, you file with the hearing officer. The hearing officer is going to want you to try and find a settlement. And then if you don't settle, they'll reach their decision. And if either you or the school appeal it, the judges and the case law is a little tighter than what you might be able to negotiate in the settlement process itself. I'm going to give you an example of this. A child who had Down syndrome was not making the progress that the parents felt was appropriate. The parents brought litigation for denial of faith and predetermination. The school district had done a lot, but it also made a lot of so many procedural problems and really didn't have very high expectations for this child and basically admitted to such. The family was able to actually negotiate a significant financial amount of money to send their child to a different institution for a period of years. There's no way that would have happened. The judge would not have ordered probably what they were able to do in settlement. But the reason they decided to settle is because it was going to be a long, drawn out litigation. And so many times school districts will say, we just don't want to go there. And or the insurance companies for the school districts will say, we don't want to go there. So settlement is actually a good thing. I want people to understand that once you're in the fight, if you can settle it, not a bad idea. Legal barriers to payment for private schooling are hard to overcome. And that's because a parent has to prove the school system failed to provide FAPE, also has to prove that the proposed or selected placement is appropriate. Doesn't mean it has to match state standards, but you still have to show that it's an appropriate placement for your child and that you've complied procedurally. The rule, if you're going to pull your kid out and then file a due process complaint and say, and I want you to pay for where my child is going, is you have to give the school district notice and say, school district, I'm telling you right now, you're denying my kid FAPE. Here's how, and I'm giving you 10 days to fix it. So it's a very specific notice and a specific time frame. If you don't do those procedural pieces, even if the facts are on your side, you're going to lose. So it's really important to understand what the steps are before you go into due process, depending on what remedy you really want. These are all the kinds of issues that you can raise in a due process complaint. These are all the kinds that I see them every day. People are fighting about placement, participation, statutes of limitation. You are required to you can bring a complaint on any issue within 2 years of the time you knew about it or should have known about it. The should have known is the hard part. When should I have known? In that case that I was talking to you about where they got a significant financial settlement, they brought claims that were outside of the 2 years, but they said, we found out that what you were basically doing with our child was having him watch videos 4 hours a day of football because he likes football, and that way he didn't dysregulate. And we didn't know until we were able to see his iPad during COVID that that's what he's been doing, because we can track what he's been doing on his iPad. So there are fights about statutes of limitations, all those procedural violations, discrimination, exhaustion of remedies. This is where you say, hey, you discriminated against my kid and I want to go directly to court. And the school district says, you didn't go through this whole IDEA process. You could have resolved it. So you're in court and you're fighting about whether you have the right to even be there or whether you have to go back to square one. There are fights about related services as opposed to medical services. There are fights about the rights of parents to be reimbursed. We talked about stay put. Let me talk about attorney's fees. In IDEA, the only way you get attorney's fees is if you file, if you win and win more than the last best settlement offer, and you file in court to get them. So in other words, the hearing officer can't say, oh yeah, and you also get your attorney's fees because you won. Even if you do win, and even if you win more than what the last best offer is, you still have to file in court to get those attorney's fees paid. You're saying to yourself, why is it so dang difficult? Why is it stacked against us? The answer is 2 ways. One, this has always been so litigious that when they created IDA back in the day, 1973, and going forward, they really wanted people to try and resolve it, so they make it an uphill climb. And 2, guess who had the money to lobby to get the laws so it's an uphill climb? Do we think it was the parents? Probably not. Anyway, the other thing that's litigated is payment for IEEs. I need to bring this up because remember I said, if you were not happy with your evaluation, you could ask for an independent evaluation and it can be paid for by the district. Some districts are taking the stance that their evaluation was good enough and they will immediately challenge you by bringing you to due process to prove that their eval was sufficient. So different districts have different takes on it. Many districts are like, I'm not paying a lawyer to go in and say the eval was sufficient because an eval costs $3,000. Depends on where you live. All right, $3,000 in New York City, you're going to buy a lawyer for 3 hours for that. They're not going to fight it. $3,000 in Nebraska, a lawyer might say, you know what, I'll do it for a flat fee of $1,500. Let's go. So be aware that an IEE is not a given, but that if you do go through due process, the hearing officer can order that and order payment for it if you did it on your own. And then there's other failures. I'm going to zip along because I promised you 15 minutes to ask questions. I want you to know that there are a variety of Supreme Court cases that have dealt with all of these issues that I've described. These are where the standards arise. So this whole exhaustion of remedies comes out of a Supreme Court case, related versus medical, all of those types of cases have gone to the Supreme Court where there's a standard and then there's iterations on those standards based on case law in the circuit courts that, what about this instead of that don't neatly fit within these. So the reason it's complex is because every circuit court is different and they have different standards and they take different stances about how generous they're going to be under IDEA. Oh, one more I wanted to point out is, where is Schaefer v. Wiest? Oh, third from the bottom. Unless there's a state statute to the contrary, whoever brings the complaint bears the burden of proof. In other words, you don't bring a complaint and say they didn't provide me FAPE and the school has to provide they did. You say they didn't provide me FAPE, you have to prove they didn't. The burden of proof becomes your job, not you. You didn't put them on the defensive so that they have to say, yes, I did, unless the state has passed a statute. There are some states that say, school district, you're so big, if somebody brings it, it's still your burden. All right. We talked about the tier statute of limitations. We've talked about the original jurisdiction, even though this is juvenile, it's not a juvenile court case. We've talked about the different levels that could be. We talked about stay put. Want you to know that the other thing is it says that a hearing should take place within 45 days, but look at this. I give you some Nebraska examples. The first thing is that the hearing officer, this is Nebraska, it's going to be somewhat similar in different states, not exact same language, but they're going to deal with all of this. Settlement, stipulations, rules on limitation of witnesses, proffers of evidence, rebuttals, cross-examination, rules of evidence, all of that has to be decided. Okay. And then you're going to develop its framework. Then there can be discovery. I need somebody to tell me who can explain the rules with regard to manifestation, because I need to call that person as a witness. So I have to discover who that school district's witness is. I might have to go through a fight to compel them to give me information, to respond to questions that are litigation questions. The point is, look at what this is starting to look like. And when can you delay continuances? There shouldn't be too many, okay? Good cause is illness of a party, fair, legal counsel or witness, a legal change in representation, or settlement negotiations are underway. Guess what happens? We try to settle because we've got this whole body of stuff that says settle, 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 settle. So by the time we pull together parts of the case and we have a settlement and we're in the process, we're halfway there, we're going to tell the hearing officer, we don't want a hearing yet, we think we're going to settle. Oftentimes this can go on for longer than 45 days. 45 days is really fast to pull together a big case. When you're at the hearing, it's like I said, there's an opening statement, presentation of evidence, cross-examination. So direct is I ask the questions, cross, you guys have all watched this on TV, right? Cross-examination, redirect of questions, recross, and then closing arguments And I have or briefs. This may be different in other areas, but in Nebraska, our hearing officer usually says, do you want closing arguments or do you just want to brief it? Every time, even though it may cost you more money, you want to brief it because that's where you can write your brief, explain exactly why your evidence showed that you win. It's a lot harder in closing argument. It's 30 minutes maybe, and it's really hard to like argue case law. So if you are working with an attorney, you want to ask for a brief if possible. Again, what are your remedies? Compensatory relief, injunctive relief, that's ordering them to comply with something, or compensatory, and multiple procedural relief could get you a denial of faith, which you could get compensatory relief. Compensatory relief is, as I said, it could be compensatory education, it could be the right IEP, it could be training for staff, or it could be like, okay, we're going to have to reimburse me for costs of my IE. You're going to have to reimburse me for costs of tuition. When you get to court, it's reimbursement usually of tuition you've undertaken, as opposed to during settlement, you could say, how about you give me some money and I'll go away and get my private education. So this is what's included in compensatory relief. I think I just went through that. Comp ed, private school, reimbursement, something to do something in the future, like develop and offer a better plan. We've talked about attorney's fees. Damages. Here's what damages are, because you all have heard about this. Compensatory, or you get pecuniary compensation because you were wronged, you were neglected, you were stressed, you lost sleep, you had emotional harm. IDA says a court can grant relief as the court deems appropriate, but spoiler alert, you're not going to get it. And here's why. All of the courts have said that the purpose of IDEA is not furthered by awarding money to parents. They basically say school districts will be inhibited in designing programs to better educate students if they're at risk for civil liability. So the majority of courts have said, you're not going to get compensatory damages. You're not going to get damages to make up for what you went through. And punitive damages, as I showed you here, that's to punish you for intentionally being such a bunch of rotters. No court has allowed punitive damages to school districts that have acted in bad faith. And that's because they say the overall scheme that Congress envisioned, which is simply to ensure a free, appropriate public education. It was not to have the things that are available in other types of harm. So I think this is hard for people to get their heads around, but the whole due process does not necessarily give you access to make you whole in the way you believe you should be made whole if you go to court. So this is to wrap it up, and then I got to be quiet. All right, so the state has to establish due process means establish your procedures, have all that parental participation, get your records, get notice if they're not going to give you something, have an opportunity to complain, have those processes that the state has to have, give you a hearing officer within 15 days of you filing a complaint. You'll get a hearing officer. You don't really get to amend your complaint, so you have to do it right the first time. It's I'll call it a regular court. We can have a first amended complaint, a second amended complaint. Like, nobody can argue with us. Here, you have to get the approval of the HO to amend your complaint, because the idea is this is supposed to be speedy, so we don't drag it out. If after 30 days the parties haven't settled, then we can start having we can have a hearing. If we have a settlement, it's a contract. We put it into writing. Civil actions, go to real court, can be brought if they're brought within 90 days after the hearing officer's decision. Keep in mind that even if you win with the hearing officer, the school district can say, I think the hearing officer is wrong. So that's not the be all end all when you win if the school district decides to appeal it. We talked about attorney's fees. The other thing I want to note is, this is another hard thing with regard to due process, is if you bring in experts, those expert witness fees are not awardable. They're not covered under the awards for attorney's fees. Because it says attorney's fees and not all the other fees for experts in IDEA, the only thing you get is attorneys. So that requires your attorney to be very creative about how to get an expert that doesn't cost an arm and a leg. The only time a district could get attorney's fees is if they can actually show your complaint was wildly frivolous. You were just in a bad mood. There was nothing that really made you. So you're pretty safe, although most districts will also say, hey, I want attorney's fees. We talked about stay put and we talked about remedies. Whew, I went over a little bit, but now I'm at questions. So I'd be happy to take questions. Sorry I had to zip through it.
That was fantastic. Thank you so much. I don't see questions in the chat yet, but I wrote a couple down.
Okay.
So my first question was, you mentioned that.
Here, I'm going to stop sharing so that we can see each other a little bit more.
Oh,
clearly.
great. Thank you. You mentioned that the school could take the parents to due process if they didn't want to grant the IEE. Are there other reasons that the school could take a parent to due process, or is that only over the IEE?
There is, okay, if a parent declines to have their child evaluated or declines to, let's say about the only time is if a parent can always say, no, I don't want services.
Right.
A parent can always say, no, I don't want to be evaluated. School district cannot argue about that. So really about the only time that they can directly go after you is if you say you did a bad job of the eval and I want you to pay for my eval.
Okay.
And they, by the way, it's not that they can, it's that they have to.
Right.
If a school district does not want to pay for the IEE, their only remedy is to file due process. So
Okay.
It's not like they're being mean per se, it's that that's the way it's set up.
Okay, that makes sense to me. The schools, so a parent has the right to say no to an evaluation. Can they also say no to reevaluations?
Yes.
Or not? Okay, so even though the schools typically are required every 3 years to
Yes.
do that, the parent still then can decline it.
Yep.
Okay, great, thank you.
The one thing I want to bring up, parents,
Sure.
with regard to reevaluation. So evaluation, initial evaluation is subject to that 45, 60-day time frame, right? And a reevaluation is not. A reevaluation is slightly different. You probably have heard this from your other presenters, in that the primary purpose for a reeval is to see if you still qualify. So I'm going to tell you, every parent that has a child with Prader-Willi is gonna qualify, okay? So sometimes states say, or school districts say, how about we waive that? You don't have to be assessed. We'll just keep your child eligible.
Mhm.
That can be okay, depending on the needs of your child. But at some point, depending on how well your child is participating, in other words, if your child has been out for a while or has not been non-participatory, we might not have the baselines that we need in terms of academics, social, emotional, or, your child also is vulnerable to comorbidities. You may have developed a new issue. Your child may not have been diagnosed on the spectrum and then down the road, or your child may have new physical issues that arise. So it's okay to say, I'll just accept that I still verify, but be cautious of getting a better picture of new baselines to give a more complete IEP.
Great, thank you.
Sorry.
The other question I wrote down, you had said if you were working with an attorney. So when talking about due process, would you ever, I know some states allow advocates to represent parents in a due process hearing, others do not. Some parents I've spoken to would want to, for financial reasons, go into that due process alone. Would you recommend that? And what are you mentioned earlier that it's off balance. the
Mhm.
school's going to come in with their attorney. Are there things that families can do to kind of, if they're struggling financially, really kind of find that balance? Are there organizations that you're aware of that help families in these situations?
So I mean, you usually have the right to have anybody assist you. That's
Right.
different than, say, an organization that's non-legal coming and say, I represent the family. That
Right.
would be illegal practice of law, right?
Right.
All I will say is you can all there in many states there are organizations that assist. Some states are like us where we are lawyers and you may find a nonprofit similar to ERC. I'm thinking, I can't think of the name of it. In Massachusetts, I know there's one. I believe there's one in Arizona that I mean, like different states. I don't practice in either Massachusetts or Arizona, but I, run into those organizations. So there are entities that can guide you and help you. There are entities that can help you write your complaint. There are entities that can help you go through it. I just know that, and I will say, the hearing officers understand that you aren't required, and they're not going to hold a parent accountable to know the law the way a lawyer would. The
Okay.
problem is that that parents, because they don't understand the law as opposed to what happened to them, don't often know what to emphasize, what matters and what doesn't matter legally, as opposed
Mhm.
to what matters emotionally and what mattered to their child. So I'm not, I do this pro bono, so I'm not in it for the money, but I do have concerns about a parent not getting at least some legal advice going through due process, just I'll call it naked. And
Mhm.
I will also say the other thing you're going to find is you're going to have hesitancy to find a lawyer that'll pick it up midstream. And that's because you can't amend that complaint very easily. So if the parents wrote a complaint and it really doesn't, it's not going to get them where they need to go, but they actually have facts that could have been alleged to get them where they need to go, a lawyer is going to say, look, I'm going to have to start all over at square one. Most lawyers, here's what they would say. They would say, I want you to withdraw I've actually had to do this myself. I want you to withdraw your complaint. You can file a motion and you withdraw it without prejudice, which means you get to file on the same facts again.
Okay.
Okay. And then I will redraft that complaint and we're going to start over so that we have a chance of winning. This is, I hate that it's this complicated, but
Mm.
I would say that it's a really scary process for parents to go through. I've seen parents that have done well. They're not that's not the norm.
Mhm. Yeah. Thank you for that. I think that, in my experience, eh, in talking with parents both in the PWS community and out, there is a misunderstanding of just how complicated this process really is.
Yeah,
So,
the one thing I would say, and we talked about state complaints a little bit,
yes.
right? I have seen states, if you can make an allegation of you didn't follow my IEP and or the school has a systemic issue,
Mhm.
and then you throw in your personal due process stuff, I have seen some states take on both.
Okay.
Okay. So you want to see if a state complaint can possibly fit your issues. If your issues are complex about, well, I got this, but I didn't get this, or they said they did this, but they didn't do that, that's going to force you into due process.
Mhm.
But if you've got some simple, straightforward claims, a state complaint is the way to go because you don't have to be the lawyer. They engage directly with the district. So it's a valuable tool.
Mhm. And when filing state complaints, you want to file the complaint and present the facts, correct? So sometimes we get caught in the emotions.
Right. Yes, that is hard. Yes. But
Okay.
I will say that states, departments of education usually have like a form. And if you
Yes.
fill out the form, it might get you there. And you can also call them and just, they won't give you legal advice, no way, but they will walk you through how to file it. And they will say, well, you need to include these things and these things don't matter.
Mhm.
Also, there are rules and regulations in every state that if you are bored at night, and you want to pull them up and read them, it
Mhm.
will walk you through exactly how to file.
Yes. Yes. Thank you. Very quickly, do we have any last minute questions from anyone? I don't see any in the chat. Okay, thank you so much, Elizabeth, for your time. I so appreciate this.